Judge, I'm just going to end really quickly with this. We didn't violate the non-dissemination order. You know, the information that now he's calling facts, you know, he's flip-flopping between whether or not it's a false fact or a fact that's in the survey. The information that was put in the survey is based on the public record and information that the way that the state and state actors put information into the public record that has now been disseminated. And we have not violated that order. And I do resent being accused of that.
I appreciate that. I mean, those two questions were not in the public record.
Based on the transcript, the survey goes beyond soliciting information and provides those being called with specific information about the case. For example, the person conducting the survey asked the following questions. Have you read, seen, or heard if Bryan Kohberger was arrested at his parents' home in Pennsylvania? Have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? That DNA found on the knife sheath was later matched to Bryan Kohberger? If Bryan Kohberger owned the same type of car recorded on video driving in the neighborhood where the killings occurred? These facts are all contained in court documents. More problematic still, the defense's commission survey also included in the survey specific rumors, which the defense should have known are likely to be inadmissible in trial. Order P.2. For example, the question that implies that Bryan Kohberger had followed one of the victims on social media. The survey also pointed respondents to out-of-courtroom coverage of this case that almost certainly contains more rumors and misinformation that would not be admissible at trial. Have you listened to any true crime broadcasts or watched any shows on YouTube that covered this case, for example, the King Road killings? On April 10, 2024, the parties again reconvened in open court. Again, neither party requested that the hearing be sealed. The questions at issue were again discussed, including the fact that some of the questions on the survey are not rooted in fact or supported by admissible evidence, but are simply rumors in the media and on social media, while other questions were formulated based on information from the public probable cause affidavit filed by the state.
Okay. They were. I mean, they came out, but that was not the court. I mean, where it came from. It just came out of the media or somewhere. Who knows where it came from? But I don't think there's anything, not that I'm aware of, somewhere. Who knows where it came from? But I don't think there's anything, not that I'm aware of, in the public record that said anything about that, about your client. In the public record that said anything about that, about your client. So, I mean, here we are. I mean, that happened. It's kind of unfortunate. I totally understand the reason to have false information out there, but I mean, I have to just want to clear that up. The other questions, that's all from the public record.
The court now orders the following : 1. The public record, as that term used in the non-dissemination order means the public court record, i.e., information from public hearings and from documents filed in the case that are not sealed. 2. Information that formed the basis for 6 of the 9 questions at issue came from the probable cause affidavit, a document filed in this case that is not sealed. The non-dissemination order expressly allows attorneys involved in the case and their agents to make extrajudicial statements, written or oral, concerning information contained in the public record. Additionally, one of the questions was not based on admissible or inadmissible evidence, but instead asked about the feelings of members of Moscow community. Therefore, the defense did not violate the non-dissemination order by asking 7 of the 9 questions. 3. As to the remaining 2 questions, prior to the hearings, there was not information contained in the public record about these media items. However, these questions have now been read into the public record and discussed at length during the hearings, including the fact that these media items may not be true. Because the information is now in the public record, the court does not see any benefit in preventing the defense from continuing its surveys or requiring that the 2 questions at issue be eliminated. Again, these questions and media items are now part of the public record, and the non-dissemination order does not prohibit the attorneys involved in the case or their agents from making extrajudicial statements about information contained in the public record.
I have a question. Anybody tell if you can find somewhere in the public record that those claims were made? I'd like to see it.
The non-dissemination order also allows extrajudicial statements that a reasonable lawyer would believe is required to protect a client from the substantial and due prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Any such statement shall be limited to such information as is necessary to mitigate the recent adverse publicity. Defense counsel argued at length that the 2 media items not contained in the public record were the subject of extensive media coverage that was prejudicial to defendant, and that the survey questions asking potential jurors if they had read, seen, or heard these media items was necessary to support defendant's motion for change of venue, which is aimed at mitigating the effects of prejudicial pretrial publicity on defendant's right to a fair trial. 2 of the survey questions were not rooted in fact, not found anywhere in the court's public record. Asterisk, have you read, seen, or heard that BK stalked the victims? Asterisk, have you read, seen, or heard that BK followed victims on social media?
I think both sides are looking at a different definition of what public record is. I have looked it up. It's the public record from the case. So that aside, I appreciate the testimony, the arguments from both sides. I think it's a challenging issue. It's something that I'm going to have to struggle through and figure out what to do. And I understand that there's some urgency to get that out, so I'll do my best. Probably not going to be this week. So, anything else we need to talk about? Ms. Taylor?
Your Honor, just the logistics of the court's decision is yet to come. We can't continue the surveys. And we've got deadlines next week, midweek, for briefing and the motion for change of venue for May. So I'm wondering if we want to consider resetting that motion and that deadline now. I still want to keep the hearing on May 14th. We have a motion to compel already filed to be heard that day, so we could still use reserved court time to make some further advances in the case. But I'm concerned about being properly prepared for the change of venue, waiting for the decision, especially if we're allowed to continue the work.
Sure. And I told you last week that I would give you more time. I want to be fair about it. So you want to change that hearing. You want to leave the May. We're set on May 14 at 1:30.
We have,
You want to keep that for the motion to compel,
yes, please.
but you want to move out the hearing on change of venue.
I believe that's the only prudent thing to do at this time. Yes, Judge, I think that we should, based on some availability of team members and experts, though, I think we're not ready, or we won't have the team available until the 4th week of June for all of the people that are necessary.
You want to just wait and just talk to each other, just, have a hearing again.
Judge, I don't think we're going to have an agreement on the change of venue issue. If I thought we could come to an agreement on that, I'd say, yes, let's not set one, let's talk.
Oh, no, I'm not suggesting that you would agree on agreement on change of venue. I just mean changing the hearing, the date.
Your Honor, we would suggest the last week of June, and if the prosecutor's ready to weigh in on that and the court's ready, we'd prefer to get a date now.
Okay. Mr. Thompson, what are your thoughts?
Yeah, I think it would be appropriate to reset the dates, and really what's going to drive this in large part, will be Your Honor's decision on what we've been talking about today. But I think it may be prudent for the court it would be prudent for the court to vacate the hearing on a motion for change of venue and prepare to reset a briefing schedule and a hearing date on the motion for change of venue to a reasonable future time.
Okay.
To allow the parties to react to whatever the court's decision may be, and I don't want the court to feel pressured on the timing of its decision. I'd rather take the time to do it right than to rush things and just bollocks it all up.
Well, I won't rush it, and I will feel the pressure.
Appreciate that, Don.
How about we set this for 1/3? We'll vacate the hearing on change of venue and reset it for January 27. That's a Thursday, which seems to be a good day. We're just generally, except today. What did I say? June. Sorry.
Your Honor,
It's a long day. June 27. I thought you said the end of June, right?
June 27 is perfect. I am thinking, though, that we should maybe schedule for a full day. We estimated an hour for this, and we are well beyond that now, and we anticipate testimony.